All right, ma'am, are you, let's see, Stacy Baker?
Yes, sir.
Okay. Just waiting for Mr. Baker to connect here.
Okay.
All right, Mr. Baker, are you able to hear me?
Yes, Your Honor, I am.
Okay, thank you. And you're Timothy Baker?
Yes, sir.
Okay, we're on the record in Baker versus Baker, case number 2419570. The record should reflect both parties are present today by Zoom video. Mr. and Mrs. Baker, the purpose of our hearing today is to determine whether or not the two of you have been able to reach any agreements on how to divide up any assets or debts in the marriage, or whether we have to schedule further hearings. So, Mr. Baker, you're the filing party here. From your standpoint, are there disputes on how to divide things up?
I don't believe so, no.
Okay. Ms. Baker, do you agree that there aren't any disputes to be resolved by the court?
Nope, there's nothing to, like he said, everything is the way it should.
Okay. All right, so I can schedule this for a final hearing then where we can finalize your divorce. There's a form that I need to have submitted to the court before that last hearing. And that form is called the Judgment of Divorce. And that form is available online. Yes, Mr. Baker?
Yes, I believe I have the form, and she and I both have to sign it. Yes, sir.
Correct. Yep, you just need to fill it out and both of you sign that.
So I just send it to her and then wait for it to come back again.
Correct.
All right. And
And then
do I need something from the post office that says she got it when she signs for it, or no?
nope, we just need her signature on that judgment.
I gotcha.
And so then I'll need you to bring that in or mail it to the clerk's office here in Gaylord.
Yes, sir. I'll bring it
And-
right to him as soon as I get it back.
Okay, so Ms. Baker, when you get that, you need to sign that and get that back to Mr. Baker, because all of this needs to happen before that next hearing, and that's gonna be in about 30 days.
Yep,
Okay,
I'll send it out today.
Okay. All
okay,
right, so I will set this for a final hearing. It'll be by Zoom, just like we're doing today. And as long as I have that document prior to that hearing, then we can finalize the divorce on that day. Mr. Baker, do you have any other questions?
No, sir. Thank you kindly.
Ms. Baker, do you have any questions?
just I'm wondering, am I gonna be able to go back to my other name, or do I keep Baker?
You can request that on that judgment of divorce. There's a spot for you to request to have your name changed.
Okay, thank you.
So if you just fill that out where it says on that form, then we can do that as well.
Okay, thank you.
Okay. All right, that's all for today, and both of you are free to disconnect at this time. Thank you.
Thank
You. Have a blessed day, sir.
You too.
Thank you.
Have a blessed day.
All right, Mr. Ryman, are you there?
I am, Your Honor.
Okay, all right. And Mr. Slough, are you able to hear me okay?
Can hear you just fine. Thank you, Judge.
Okay, great. We're on the record now in Ryman versus Boathouse Marine and Power Sport. This is case number 2319395. We have both parties connected by Zoom today. And I believe we have this set for a status conference. And Mr. Ryman, you've got a motion to compel. I did have a chance to receive your motion. I had a chance to review that. Mr. Slough, I did receive your response and I had a chance to review that as well. Mr. Ryman, as to the motion to compel, was there anything further you wanted to present today by way of oral argument?
I'll be very brief. I appreciate counsel and the court letting me put it on such short notice. Operating with a little bit of difficulty here because I'm down in Florida on vacation. I'll be back in a week or so. I didn't want to wait, especially with this hearing opportunity coming up for us. Your Honor, as I said in my motion, Mr. Slough advised his client not to answer a couple of questions. And as the court and counsel know, the Michigan court rules have been amended several times on discovery issues and especially depositions over the last 8 years, most recently in 2020, to very clearly say in 2.306 C5, a person may only instruct a deponent not to answer to preserve a privilege or to enforce a limitation, previously ordered by the court. And if it's something other than that, then counsel was supposed to make a motion to terminate or limit, file a motion before the court to have the deposition continued to enforce his either objection or advice to his client. This wasn't a harassing situation. It's a very relevant issue. Both myself and a couple of other witnesses have testified that there's this other customer who was waiting 18 months for his boat for a similar repair. And Mr. Boyke kept telling me, you and the other guy, but he refused to give us the name. And then also during the deposition, Judge, there's another damage issue that came up when I did get my boat back after suit was filed that had a hole in the hull. And during the deposition, Mr. Boyke said, well, that was your fault. You should have noticed that I put it on the trailer wrong. I did break another guy's boat, but not yours. And I said, okay, whose boat did you break? And then counsel refused to have him answer. It's a clear violation of the court rules. It's a clear violation of the way the Rules Committee and the Supreme Court has directed depositions to be conducted. And so the next day, I thought maybe counsel misspoke when he said that he wouldn't let him answer because it's proprietary. I don't know that that's a thing. And I tried to understand what he meant. So I emailed him the next day and said, hey, can you just email me those names and contact information that you have had him refuse? And he said, no, file a motion. So it's not that counsel doesn't know what the court rule is, and it's not that he doesn't know this is a clear violation of the court rule. I don't know why he wouldn't let his client answer, but we should be allowed to get that information under the court rules and continue the deposition at his cost. I do have a $130 appearance fee for the court recorder and a $25 travel fee, in addition to I had incurred attorney fees regarding this motion to counsel on filing this motion and the $20 motion fee. The final thing that was part of my motion, Your Honor, is that a new name came up during Mr. Boyke's deposition, this Buster. And he's not an employee, and as far as I know, I'm not sure what was counsel denied my allegation, but I don't think his name was disclosed in the initial disclosures. And certainly is important because Mr. Boyke said he's the one who did most of the work on the boat and he paid him to do it. So I need to contact that person. I didn't have time in discovery. And I'm not asking for any delays in this case. Mr. Slough wants to have his expert review my boat. And I said, that's fine, but it's in winter storage. So you can come to where it is. And I didn't even deny bringing it to where he wanted me to bring it. I just said, if you're going to open it all up, it's got to be winterized again. Or we can wait to better weather. So we just reached a compromise that we'll wait till better weather. And so we're going to have discovery on the inspection at that point, and then I can depose his expert. I think it just makes sense. Leave discovery open. I'll deal with Buster and any follow-up questions I have with these gentlemen's names with the continued deposition, and it won't slow the case down. Mr. Slow wants to get it trial by July or whatever. I agree. And I don't think my request to keep discovery open should delay the case. Thank you.
All right, in reviewing your complaint, Mr. Ryman, you've got a claim for breach of contract, a claim for theft or conversion, and then a claim for equitable relief asking the defendant to, essentially put your boat back together and return it to you. And Mr. Slough raised this, and I'm sure he's going to raise it in his argument, raise it in his written brief, so I'm just going to ask you about it now. What is the relevance of whether or not, the defendant in this case had problems with other customers? What's the relevance of that to your claims here?
Yeah, well, whether it's relevant is a different question as to whether it's discoverable. The court rules make a clear distinction on that. So I don't mind having that argument on relevance, but I think first I get to discover it, talk to the gentleman. If, as was claimed by another employee of the boathouse, that gentleman was in the same boat as me as far as being given promises on deadlines. And they always said, you and the other guy, Kevin, we got your boats. We're going to have you in the water first, you and this other guy. It's not privilege. There's no privilege. And under the court rules, if there's no privilege, then I can discover it and find out if it's relevant, or judge even lead to relevant evidence. I can't say at this point, but I do think this is not a character issue. Counsel is trying to say it's 404B, he's got a character trait for doing some things. No, it's his competence and his ability to do jobs he agrees to do. I think, although I don't know because I haven't been given the answers, but I believe the other gentleman was expecting engine rebuild as well. And I think the evidence that is going to tend to show Mr. Boyke did not have the ability to do an engine rebuild. So I just want to talk to the other guy. That's all. That's one of the guy. And then the guy who broke his boat, Judge, I'm alleging that he put a hole in my boat after I filed the complaint. That's part of what the inspection's about. The fact that he's testified he broke this other guy's boat, I'd like to know how. Maybe they have a way of doing. I think I know there's two ways mine might have happened. And I just want to find out if he has a mode of operation or, a policy or thing that's causing him to put holes in boats. And the only question under the court rule is if there's a privilege. Those privileges are mostly limited to medical and attorney-client. Court rules say, let you find out, and you can argue in the future whether it's relevant and admissible. I just need to find it out.
All right, well, the rules do require it to be relevant, right? Admissibility is something that could be determined later, but you can't ask about anything under the sun. It has to be relevant to the case. So there is an element of relevance to the discoverability of information, isn't there?
No, not as to taking a deposition, Your Honor. The only question is whether it's reasonably calculated to lead to relevant information. And this is
whether it's reasonably calculated to lead to admissible information. And I'm looking at the court rule. It says parties may obtain discovery regarding any non-privileged matter that is relevant to any party's claims or defenses. So,
okay. Well, I stand corrected, but nevertheless, how is it not relevant whether the guy is competent, the defendant is competent to do engine rebuild? Now, he's claiming he didn't agree to do an engine rebuild. That's a fact question. But my claim is he agreed to do mine and this other person that he constantly referred to, and that he wasn't able to do either one. So it's not character evidence. He's not competent, as shown by his work at the same time. If it's not privileged, how is it not relevant?
okay, thank you. Mr. Slough?
Thank you, Judge. And I think the court is understanding the issue. The plaintiff is not entitled to just undergo a fishing expedition in a deposition. And what the court rule actually says is that at any time during the deposition, if the deposition is being conducted in bad faith or in a manner unreasonably to annoy, embarrass, or oppress the deponent or party, that the person being subjected to that can essentially suspend the deposition and seek an order for protection. Now, I didn't suspend the deposition. I could have, but in good faith, I allowed the deposition to continue in the interest of time and money, with the understanding that Mr. Riemann was going to file a motion to get this straightened out. So, I wanted to address what happened at the deposition. Now, in terms of this case, I mean, this is a basic breach of contract case over a used boat. The allegation is that my client made certain promises that he denies making. But these promises are things like liquidated damages and to have the boat done by a certain date, and that it would be a complete rebuild of the motor. And how my client's other customers would have any knowledge about what my client and the plaintiff agreed to, I just don't understand. I don't understand in any way how any of this would be relevant. The plaintiff continues to assert that somehow he's going to prove that my client's a bad mechanic or that he misses deadlines. But that's just not what this case is about. Moreover, it's not admissible because under 404A, you can't use character evidence to try to show that a person acted in conformance with those characteristics in a certain situation or on a particular occasion, rather. I cited the case in the brief. There's another case from the MJI evidentiary bench book, and it's People v. Roper 286 Mishap 77. It basically says such evidence is strictly limited because it's highly prejudicial in nature. This idea that if you try to present a bunch of evidence that someone acted in conformity in a certain way in the past, it's gonna be highly prejudicial in presenting whether they acted that way on that particular occasion. So it wouldn't be admissible even if there was any basis for and if there was any truth to these allegations that these other customers were unhappy or that somehow my client's not a good mechanic, which again, there's just no evidence to support that. So we would ask the court deny the motion on that grounds. The other request to keep discovery open with regard to Engines by Buster. Engines by Buster, my understanding, was just a subcontractor. That's what the testimony was at the deposition. They did some minor work on this motor. Plaintiff testified that he's not even tested the motor. So he can't present any evidence that this motor is not in good operating condition. Again, the issue in this case is, number one, did my client damage the hull of the boat, which Engines by Buster wouldn't know anything about that. And two, did my client promise to do certain things that he didn't do? And again, Engines by Buster would have no knowledge about any of those conversations between the parties. So again, we're engaging in a fishing expedition here for something, and I don't know what he's looking for exactly, but there's no reason to extend discovery. We've had an adequate discovery period here. We've got one limited stipulation because plaintiff's boat is down in Bay City that we're going to have my expert look at it here a little after the discovery deadlines. We've straightened that out, but there's just no reason to just continue to extend discovery. This is really a district court case. We need to just get it done. Thank you very much.
Thank you. Mr. Ryman, it's your motion. Anything you wanted to say in response?
Yes, thank you. I appreciate the opportunity and your patience. Counsel says there's no evidence that his client is not a competent mechanic. That's because he will not disclose his customers who were unhappy or got a bad result. So how do I prove that he's not a competent mechanic? This is the whole case. The breach of contract case is that he agreed to do certain work and returned the boat to me in operable condition, and that he didn't do that. Of course, when I filed the complaint, he wouldn't even tell me where the boat was. So we had some communications. He put it together. It didn't work. He took it back. He gave me a video that says it works. And then he put it on a trailer and he brought it to me at a restaurant and he said, "It's all set, Kevin." He came to my table. And then, so we went out, it was dark. We hooked the trailer up, towed it home like normal, and we went out in the morning and it had a hole in the hull. So counsel is correct. I haven't tested the boat because I can't put it on the water. Since I've taken it to Mr. Boyke 2 years ago, I can't put it on the water. It has a hole in it. And Judge, I know counsel loves to say bad stuff about me, and he's got me. He's going to be able to show that I've a prior crime that goes to credibility. But Mr. Boyke admitted at his deposition that out of the thousands of rebuilds that he claims to have done, never before, ever, except to me, did he ever stick in the motor one piston that was considerably different size from the others in the motor. He said, I've done thousands of these. No, Kevin, I've never done that before, but it's yours isn't a racing boat. It would probably be okay. I mean, he's admitted he didn't do this properly, but the question of whether or not he's competent is not a character issue, and it is relevant because I'm claiming he agreed to return it. He said he could do it, and he didn't, and I'm trying to prove that he can't.
All right, thank you. With regard to discovery and whether or not the court should permit discovery or prohibit certain discovery, it's all a matter that's within the discretion of the court. Michigan generally follows a policy of open, broad discovery. However, the policy allowing for open and far-reaching discovery does not encompass fishing expeditions, and there are limits on it. As I indicated before, parties may obtain discovery regarding any non-privileged matter that's relevant to any party's claims or defenses and proportional to the needs of the case. And again, whether or not requests are within that scope of discovery is within the discretion of the court. As I also indicated earlier, the court need not make preliminary decisions regarding the ultimate admissibility of evidence as long as it's relevant and likely or reasonably calculated to lead to admissible evidence, or the evidence itself is admissible. The court should allow the discovery. In this case, again, I mean, the court is looking at what are the claims and is this requested discovery relevant to those claims. The claims, again, are breach of contract, theft or conversion, and equitable relief. In this case, the court finds that whether or not the defendant in this case had problems with other customers, had disagreements with other customers, really isn't relevant, I don't think, to the plaintiff's claims here. It's whether or not the defendant breached a contract as it related to his agreement with the plaintiff, whether he engaged in any actions that could qualify as theft or conversion, and whether or not the plaintiff's entitled to equitable relief. But that's going to be very specific to the agreements and the actions that took place between the plaintiff and the defendant as it related to his equipment, and any actions that the defendant actually did undertake with regard to the plaintiff's boat. And unless somebody else had an exact replica word for word of the transactions that occurred between the plaintiff and the defendant here, none of that really is going to be relevant. So it just doesn't have anything to do with whether the defendant engaged in wrongful conduct related to the plaintiff here. So the court finds that questions with regard to other customers of the defendant are outside the scope of the discovery, and the court will deny that motion as it relates to those other customers. Now, as it relates to Engines by Buster, or this individual named Buster, if he did perform work on the plaintiff's boat, and that's a fact that just became apparent through the course of discovery, then I think the plaintiff is entitled to discovery with regard to Engines by Buster, and what work was performed by Engines by Buster on anything belonging to the plaintiff on behalf of the defendant. I think that is relevant to the plaintiff's claims here, and plaintiff may have claims against Engines by Buster, or may seek to add Engines by Buster if it turns out that that individual or that individual's company did work on the plaintiff's boat and caused some type of damage. So I do think that to the extent that but Engines by Buster, or there's been some admissions by the defendant that Engines by Buster did some amount of work on plaintiff's boat. I think plaintiff's entitled to discover that, and I think plaintiff's entitled to direct some discovery at the defendant to find out if in fact that occurred and to what extent that occurred. So the court will grant a 60-day extension of discovery. The court will grant that in terms of discovery requests that are directed at that issue of Engines by Buster did work or was work done by Engines by Buster on any plaintiff's boats, and to what extent. And the extension of discovery would be limited to those kind of issues and would need to occur within the next 60 days. So Mr. Ryman, if you'll prepare an order that reflects the ruling of the court today and submit that either with a stipulation as the form for Mr. Slough or under the 7-day rule.
Yes, Your Honor. Could I have maybe 10 days to submit that order? I might be able to do it from here. But I might not be able to.
I can submit the order if that's easier.
Okay.
That's up to two of you if you want to agree on a mechanism for submitting the order. And
I know it's typically 7 days under the 7-day rule, and that's the day I'll be getting home, I think. So
I can prepare the order and send it to Mr. Reedman to review.
okay, that's fine. If you want to do that, Mr. Slough, and then Mr. Reedman, if you object to the order, you just need to file an objection and we can have a hearing on that. Okay, that's all I have for today, and all parties are free to disconnect at this time. Thank you.
Judge, will there be another?
Your Honor, could I try to?
I'm sorry.
Oops.
Go ahead, Mr. Reedman.
And I'm sorry too, I just wanted to try to catch them. Judge, we have one more issue. I don't know if you could maybe give some clarity on. There was some issues regarding my boat that I was not aware of when I filed this complaint. And then about it, the defendant and I did had some efforts to try to resolve the issue. And when I did get the boat back, it had a hole in the hull. My reading of the court rule says as long as it's not a surprise, the claim should be amended to conform to the proofs, even at trial. And I just want to understand if the court prefers. Counsel and I had originally talked, I'll file a counterclaim, but I just didn't see the reason to do that. My claims in the complaint, yes, read in contract and conversion because I couldn't get my boat back and I couldn't get the work done. But the claims of the contract are that he agreed to do the work and return my boat in quality condition, that he didn't do that. And my impression is that putting a hole in my hull so I can't put the boat in the water, which I gave him an opportunity to fix, and he agreed wasn't in my boat when he got it, that falls under that contract claim. And if the court is not inclined to see it that way, could I amend the complaint, which is no surprise to the counsel, to just say Andy put a hole in my boat before he returned it?
So, I go on the written pleadings. The court has to go on the written pleadings of the parties. So if you have claims that haven't been set forth in your initial complaint, then I think you would need to amend the complaint. I think we're past the period where you can amend it now without leave. So I think you would need to file a motion for leave to amend the complaint or seek a stipulation from Mr. Slough. And we would have to proceed that way.
Very well.
Judge, my question was just, are you going to set another status conference at the close of the 60-day discovery period? And should we put that in the order?
Yes. Yeah.
Okay. Thank you. That's all I have.
Okay, thank you. I have to move on my docket, so all parties are free to disconnect on this file. Thank you.
Thank you.
Thank you, Your Honor.
In the corner there. She's the clerk. that Susie defines it?
Yep.
Okay, looks like we have everybody connected. We'll go on the record in Tronic versus Trionic, case number 2219141. Council President, you can put your appearance on.
Good afternoon, Your Honor. Mark Dundon appearing on behalf of plaintiff Leanne Tronic.
Good afternoon, Judge Elliot Blumberg on behalf of Donald Tronic, who's appearing via Zoom from my office.
Okay, thank you. Mr. Blumberg, I believe we've got, or no, Mr. Dundon, is this your?
It's our motion, Your Honor, to fix a clerical error because the wrong list was attached to the judgment. So that's what we're here for today. And in my opinion, hopefully the court agrees with us. And if you do, then I think everything else, I think we have to go to mediation on any personal property dispute. But I guess I'm getting a little ahead of myself.
Okay, oh, go ahead. Sorry.
I could largely rely on the pleadings. I mean, if the court has any question, I don't like admitting I didn't look, but I didn't look closely enough at the list. I think we laid out the timeline here, exactly what happened and when. And if the list is rectified, I think we go back to the regular terms of the judgment, Your Honor, at which point we're supposed to go to mediation for personal property disputes. But I definitely, I can just take the court back through it briefly. I mean, we were on January 17th, I did get a list from Mr. Blumberg that, said this is his list. We were going to send lists back and forth. I attached the email and the JPEG to the court, and then I sent that list to Ms. Tronic, which is attached as Exhibit B. Then I believe the pro-con was January 19th. After that, we signed the judgment on January 22nd. And then I was supposed to get a better copy of the list. And that we were going to attach to the judgment on February 1st. I did get the email saying that Elliot finally found it. And I attached that list as Exhibit C. And again, Your Honor, it's my bad. I didn't check the two lists next to each other. So we attached the list that I got on February 1st. And that one, my client didn't even have until February 8th. In the interim, she had sold a gun safe. And that's why we're seeking to correct this list. If the correct list was attached, Your Honor, there's no question that she did not violate the terms of the judgment. And they can, again, the way the judgment's laid out, they're supposed to go to mediation for personal property disputes. And even the lists themselves don't guarantee, neither of them is guaranteeing to the other one that they have whatever is on the list, Your Honor. So, we would ask the court to allow us to attach the list that came on January 17th and get the judgment, nunc pro tunc attach that list, Your Honor.
All right, thank you, Mr. Blumberg.
Your Honor, with all due respect, Mr. Dundon is being unduly kind in regard to his client. At no time was this gun safe ever on Ms. Tronic's list of personal property. It was my client's premarital gun safe. Ms. Tronic had exclusive use of the marital home for almost a year prior to the sale of the house. The personal property list that she had prepared did not say the gun safe, and yet she took it upon herself to sell it, knowing that it didn't belong to her, knowing that it wasn't awarded to her, and it's a gun safe worth thousands of dollars. Moreover, when the house sold, again, Ms. Tronic disposed of the washer and dryer, contrary to the express terms of the purchase agreement. Mr. Dundon didn't do anything wrong here. Ms. Tronic, the individual that has sold things that she wasn't awarded, gave away and took things that she shouldn't have. redoing the personal property list isn't going to resolve this problem. She sold a gun safe that she wasn't awarded. She gave away or took the washer and dryer that she shouldn't have. So again, what Mr. Dundon's asking the court to do isn't going to resolve this problem. Your Honor, there is a show cause hearing on May 6th next month for her to come forward to show why she should not be held in contempt. We want the gun safe back. She sold it. She's kept the money for it. She hasn't denied that she sold it. She hasn't come forward with by way of affidavit and say to the court, oh, by the way, I was supposed to get the gun safe. She knew she wasn't supposed to get it, but because she had exclusive use of the house, she felt that she could get away with this. So with all due respect to Mr. Dundon, I don't think redoing the personal property list is going to resolve this issue.
Your Honor, may I respond? The personal property lists were never meant to be exhaustive. Neither of them, and that's why we even wrote in here that they're not guaranteeing that anything is on there or, that anything is there. And again, there would be no possible way to hold her in contempt on the January 17th list. She wasn't required to list every stick of personal property, neither was he. They're both getting stuff. This was just lists they each put together based on what they remembered. So this, again, Your Honor, I think it's critical if the court attaches the other list, then she didn't violate the court order. She, by the way, can testify that the gun safe was bought when they lived in Pennsylvania. She can, if we get there, which I don't think we do yet, but if we get there, she can explain why it was indeed purchased after the marriage. And it is marital property. And then, Your Honor, if we get to that point, he's free to go to mediation, so are we, and they can each say, I should have gotten this, I should have gotten that. And I think that's the idea behind this judgment. As far as the washer and dryer, Your Honor, my client was not given the purchase agreement ever. She didn't get it until February 20th, when it was sent to me when I was in Florida, which, it is what it is, but she was not part of the purchase agreement, was not privy to that contract. So again, if there's a problem there and it's a personal property issue, we think no one should be show caused. We should be in mediation, seeing if we can resolve this. But I do think switching out the list is pretty critical, Your Honor.
If I may just
Additionally, sorry, but my client also, her personal property that she was to be given was given back after, I believe, the house had sold. So my client can't get, her stuff is locked in the garage with the new owners. So it's, so we would ask you to allow us to attach the correct list and then send us to mediation per the terms of the judgment, Your Honor.
Judge, when the house sold, $5,000 of my client's sale proceeds were held in escrow pending a walkthrough of the house. That's when it was discovered that Ms. Tronick took the washer and dryer from the house. She was not entitled to that. And whether she knew it or not, it wasn't hers to take. It went with the house along with the other appliances. But that's not for today's proceeding. That's for May 6th when we have the show cause hearing. The court's already signed an order. She's being required to appear on May 6th at 2:15 to show good cause why she should not be held in contempt. Right now, we're talking about the gun safe that she wasn't awarded, that she sold, that she acknowledged she sold, and she's kept the money. Why would she be entitled to that?
Your Honor, if it's marital property, which she can lay out why it is, then you're right. He maybe is entitled to half of the money that came out of the sale of the gun safe, but we can go to mediation to discuss any personal property issues as called for in the judgment, Your Honor. There was no purposeful, nefarious thing done in any way. And my client will testify on May 5th or May that she had told the listing agent that she was taking the washer and dryer. But again, that's not for today. Today, we would just ask the court to allow us to add the list that should have been been placed on there, and then I think we're back to the status quo and we would go to mediation, Judge.
Well, is this gun safe on either of the lists?
Yes, it's on my client's list.
It's
Okay.
on his list, Your Honor, it's on his list that was attached by mistake. You can, again, we laid it out
Okay,
pretty.
but Mr. Dunnan, hold on. Mr. Blumberg's saying it wasn't a mistake. So, I mean, I can't just believe one of you over the other based on what you're saying. I mean, you're saying it was a mistake. Mr. Blumberg's saying it wasn't a mistake and that his client was supposed to get the gun safe. And if he's not going to get the gun safe because it was sold, then he should get the proceeds to the gun safe. So, I mean, we got a fundamental problem here because there isn't any ruling that the gun safe is marital property. It doesn't appear that we have an agreement of the parties as to who's going to get the gun safe or the proceeds from the gun safe. So, I mean, I think that's a bigger problem than just, and we're not dealing with, you know, a salad bowl here. We're dealing with a gun safe. It's not something that parties would typically leave out of an agreement. You know, we're not talking about a small piece of personal property that, you know, maybe everybody forgot about. And when the house is being cleaned out, it's like, oh yeah, here's this, which in my view is the kind of thing that under the judgment, you would go to mediation to determine then, okay, we didn't know about this or we all forgot about it. Now we need to figure out who's going to get this piece of unaccounted for property. But the gun safe is not that kind of thing, in my view. And for the court to correct a mistake, I think everybody would have to agree that it was a clerical mistake.
I don't think Mr. Blumberg is disagreeing that the list was not the one sent on the 17th, which is why I thought Mr. Blumberg and I did agree that that it was a mistake, that the wrong list was attached, Your Honor. That's the one we got on the 17th is the one I sent to my client. I did not look closely enough at the one on February 1st, but these people have all kinds of property that they didn't put into different. My client has a bunch of hairstyle stuff. There's all kinds of stuff that wasn't put on her list. She didn't itemize everything, Judge.
Yeah, and I understand that, but I mean, a gun safe is kind of a big piece of property. Right? I mean, it's not something that fits in a drawer that we just don't have time to itemize. It seems like that would be something that the parties either would agree on or not agree on. And
No, I would agree, Judge. We got to decide who gets it, but that my client didn't get the list until February 8th. She sold it on February 4th. We have to decide who gets it, but it's kind of like the washer and dryer. I would think we could go to mediation if my client is given the list as that he sent on February 17th, then he didn't have it in there either. He didn't put the gun safe.
And Judge,
but,
if
but
I
my point is, I guess my point is this is, you know, the gun safe, whether it made it on the list or not, from what Mr. Blumberg's saying is that was part of the overall agreement of the parties.
And it's in my client's affidavit, Judge, attached to our response to this, along with the fact that he purchased it at Burke's Gun Shop in 2010 prior to marriage. Ms. Tronick hasn't come forward with any evidence, even asserting any entitlement to it.
Well, Your Honor, all I was filing today was trying to correct the clerical error, Your Honor. This is what I was seeking to do, because in my opinion, if it's not on his list and it's not on her list, then it should be decided in mediation. That's what we're asking the court to do. If it's, she didn't put it on hers, he didn't put it on his that I got on January 17th. And she disputes all those facts, but I believe if the court allows me to fix my error, and it was my error, I didn't compare the one on February 1st to the one that I had already gotten January 17th. Well, I looked at them quickly. They're both handwritten, and I just attached the second list, which I should not have done, Judge. If that's fixed, then he's free to say it's his individual property prior to marriage. She can say it's marital property. If it is marital property, he would be, no matter which way you slice it, due half the value. We don't disagree with that. He would, if it's a marital asset, he's due half the value of the gun safe. It's just there was no willful, sinister motive here. She didn't even get the list with the gun safe on it until 4 days after she sold it. I gave it to her February 8th.
Judge, I think the fundamental question is, why would she think she was entitled to the gun safe, the washer, and the dryer? She just helped herself because she had exclusive use of the home. My client hadn't been in that house except one time in probably a year. And it was only afterwards that we discover, after the sale, that these things were missing. And again, I appreciate Mr. Dundon's attempt to cover for his client. He's not the fault here. He didn't make the mistake. I think this falls at the feet of Leanne Tronick.
All right, well, I think what I need to decide, first of all, before I can correct anything, is I need to know or make a decision as to what the agreement was between the parties. Because if the agreement was Mr. Tronick was supposed to get the gun safe and it just didn't make it into the list, that's one thing. But if Ms. Tronick had no idea that he was supposed to get the gun safe and it didn't make it in the list and then she sold it, that's something completely different. And sitting here right now, I think I need to make some factual findings as to which scenario it is, because Mr. Tronick's version is that he was going to get the gun safe, she knew it, and whether it was on the list or not, she sold it and shouldn't have. Mr. Dundon, you're saying nobody had any agreements with regard to the gun safe. It wasn't on the initial list, and she didn't know it was supposed to go to him until after she sold it and got his list. So those are two completely different factual scenarios that I think the court has to make some findings on, because the parties certainly aren't agreeing on which one is correct. So what I'd like to do is proceed on March 6th. We already have a hearing scheduled that date. That's going to give the two of you time to figure out how you want to approach this from an evidentiary standpoint. But I would expect the court will take some evidence on that date. And I've got to make that initial finding. And then if the court finds that the gun safe was part of the agreement, it was supposed to go to Mr. Tronick, then I think Mr. Blumberg's got an argument that she violated the agreement by selling it. If the court finds that either the parties didn't agree on who was supposed to get it, or it wasn't ever addressed by the parties, or Ms. Tronick is entitled to half of it, then that leads us down a completely different path. So I'm not going to rule on the motion to correct, because I don't think it's a motion to correct. I don't think there's something that needs to be corrected. I think there's factual findings that need to be made by the court. So we'll proceed on March 6th. With that hearing, both sides should be prepared to address that issue of who was supposed to get it, when the agreement was made, if there was an agreement, and so forth. And then we can address the issue of the washer and dryer on that date as well. So in terms of your motion, Mr. Dundon, the court's going to hold that in abeyance, and we'll proceed on March 6th. Mr. Dundon, do you have any questions about that?
No, Your Honor. I'm good to go.
Mr. Blumberg?
Is that going to be in person or via Zoom?
I think it's set to, let me see. It actually says,
It's currently set for Zoom, Judge.
okay, then we're probably going to have to switch that around. And I may have to build in some more time, because it's probably just set as a 15-minute hearing too. So I'll have to talk to Jennifer. I don't want to say too much more in terms of scheduling on the record here without knowing exactly what's going on, but it'll need to be an in-person hearing, certainly.
Thank you.
Okay. All right. Thank you. All parties are free to disconnect at this time. Mr. Dundon, I think you're on for the next case, actually, if you want to stay.
Yes, Your Honor, I just gotta see my client. Could I have 2 minutes, Judge? No,
Yep,
get the
absolutely.
client back.
Yes.
Thank you. Oh, yeah.
Mr. Grote, I just had a prior hearing with Mr. Dundon, so he had to get his client for this file, so it'll just be 1 second.
Okay, great. Thank you, Your Honor.
Is your client joining by Zoom today?
No, he is not. Mr. Dundon and I had spoke last week and we're just finalizing some discovery. So I didn't think his client was going to be joining either, to be honest.
Okay, and that's fine. I just have a general iPhone logged in and I'm not sure who that is yet, so
Okay.
wasn't sure if that was your client signing in or somebody else.
No, it should not be mine, Your Honor.
Okay. Okay, let's go on the record in Lester versus Lester. This is case number 2319497. And if I could have counsel put your appearances on in this file, please.
Travis Grote on behalf of the plaintiff, James Lester.
Mark Dunnan on behalf of defendant, Ms. Lester.
Okay, this is set for a scheduling conference in this case, or a status conference, I'm sorry. We last time we talked was back in February. Mr. Grote, can you tell me where things are at from your side?
Sure. Thank you, Your Honor. At this point, we are just finalizing some discovery. I think that hopefully once the discovery is complete, Your Honor, we'll be able to wrap the case up with a pro confesso hearing would be my hope. If not, we would come back before you and set the matter for trial if there are issues that we're not able to resolve.
Okay, when would you suggest the court setting that either final hearing or status conference? How far out?
I would say 45 days, Your Honor, would be appropriate.
Okay, thank you. Mr. Dundon?
Yeah, that's everything's correct, Your Honor. 45 days would be about right.
Okay. I can do that. I will put in the notes to set this for a final hearing slash status conference. Mr. Grote, anything further I can address for your side today?
No, Your Honor. Thank you very much.
Mr. Dundon?
No, thank you, Judge.
Okay, thank you. You're both free to disconnect on this file.
Thank you.
Okay, on the iPhone, counsel, if you can you tell me your name, counsel?
Yes, I'm Scott Norton. I'm representing Dean Bach.
Okay, very good. Thank you. We're now on the record in TBF Financial versus 45 Degree Hospitality. This is file number 2319505. We have Mr. Norton's appearance on the record, and counsel for plaintiff, can you put your appearance on, please?
Good afternoon, Your Honor. Daniel J. Pico, P58733 on behalf of plaintiff TBF Financial.
Okay, thank you. This is set for a scheduling conference hearing in this case today. Mr. Fico, from the plaintiff side, can you tell me where things are at?
Well, I did serve out some discovery back in early February, which I did get a little ahead of myself. Mr. Norton reminded me that I had not yet filed an initial disclosure, which I promptly did, which should show in the court file. So I believe my discovery responses are due, or perhaps even slightly overdue.
Okay, Mr. Norton?
That's correct, and I will have those for him within the next 5 days.
Okay. How do you guys want to schedule this going forward? Do we want to set a deadline for discovery? Do we want to set a mediation deadline? I mean, how do you guys see this case moving forward from a scheduling standpoint?
I think if the court has a standard scheduling order, I don't think we need a whole lot more discovery time. I'm not sure mediation would be helpful. This probably is something that could be resolved with the summary motion, I would think.
Okay, Mr. Norton?
That sounds right. One of the parties, 45 Degree Hospitality, has stayed from the matter as a result of a federal court receivership. So I'll be answering the discovery, probably a minor discovery of my own, and then I don't know the case val is going to be of any real help to us, but we could go to a facilitation, see if we can get it resolved prior to motions for summary.
All right. And Mr. Fico, it sounded like your thought was to have dispositive motions first and then look at ADR after that.
If the court believes that the facilitation might be helpful, I guess I'm willing to go along with that, certainly. In my experience, I guess these kinds of fairly clear-cut contract issue type cases, I don't know if they really lend themselves to a facilitation or a case eval type of resolution, but
I'm not opposed to that. We can, why don't we get the discovery exchanged and move for, and the plaintiff can make its motion for summary, or a defendant.
I
All
know.
right, why don't we do this? Because I think if the court is going to order mediation, just based on what you're both saying here, it might be more productive if each side has a chance to have dispositive motions heard and ruled on. So what if we say 90 days going forward from today, further for discovery, and then a dispositive motion cut off at 120 days. That would give you 30 days after the close of that 90-day discovery period to get any motions filed. Mr. Fico, any objection to that?
Not all. That sounds very reasonable to me.
Okay, Mr. Norton?
Works for me as well.
All right, and then I will set this for another status conference at about 120 days. So if for some reason there aren't any dispositive motions filed, we'll have that date set to get together and talk. We can kind of see where things are at if no motions have been filed, and conduct further scheduling at that point. And we'll go from there. And I'll put all of that into an order and get that to both of you. Mr. Fico, anything else I can address for your side today while we're on the record?
Nothing further.
Mr. Norton?
Nothing further.
Okay, again, I'll put that into an order and get that out to you, and you're both free to disconnect. Thank you.
Very good. Thank you.
All right, we'll go on the record now in Trevor versus Northern Food Group LLC, Anchnek and Benell. This is case number 2319554. If I could have both counsel put your appearances on.
Good afternoon, Judge. Elliot Blumberg on behalf of the plaintiff who is in my office appearing via Zoom.
Paul Slough, Your Honor, on behalf of the defendants.
Okay, and Mr. Slough, I don't see your clients signed in.
Yeah, they're probably watching on YouTube, Judge. Thank you.
Okay. All right, sounds good. Mr. Slough, this is your motion for summary disposition, particularly as to counts 1 and 2, but it sounds like also as to count 3 in lieu of a motion for a more definite statement. I did have a chance to review your motion and accompanying brief along with the attachments that you submitted. Mr. Blumberg, I did get your response and had a chance to review that along with the attachment there. And then Mr. Slough, I believe you filed a reply, brief reply, which I had a chance to read. So I'm kind of familiar with the facts and the issues here. Mr. Slough, anything by way of oral argument in support of your motion today?
Yeah, just briefly, Judge. Thank you. Yeah, as you know, this is a lawsuit by Mr. Trevor involving his role as a manager in Northern Food Group, which operates a Jersey Mike's franchise in Gaylord. He was co-manager in the company, and the other co-managers elected to exercise their authority under the operating agreement to remove him from the company. The basis for that is set out in section 6.6 of the operating agreement as last amended and agreed to by Mr. Trevor. And that language makes it very clear that if there is a for-cause event, that the other co-managers may remove a member from the company. That for-cause event being defined as any of the following: a member being arrested, charged, indicted, or convicted of a felony, or is convicted of a crime involving moral turpitude, or any crime or offense that would otherwise compromise the ability of such member to remain as a member pursuant to the company's franchise agreement with a sub-above LLC. And that franchise agreement I cited in the brief contains a provision that indicates that no franchisee or owner of a franchisee shall be convicted or plead to a felony or any other crime or offense that is likely to adversely affect the reputation of Jersey Mike's system. So the issue here is that after opening this company, Mr. Trevor committed a series of acts involving moral turpitude. And these were mostly admitted to in a hearing before a referee in this court on a family case, including, and I won't go into great detail here because I spelled it out both in the brief and I provided a link to the testimony. But there was an inability to control using profanity in public, sexual and physical assault of his child's mother during custody exchanges, destroying her cell phone as she attempted to call 911, which resulted in a felony arrest and charge in direct violation of the operating agreement, verbally assaulting a waitress in a bar, admissions that he doesn't trust the government and that he believes a friend of the court is a money laundering operation. And additionally, we submitted an affidavit from my client outlining the harassing behavior to employees and the inappropriate conduct with minors. Based on all of this, my clients decided that he needed to be removed from the company under section 6.6. We filed this motion for summary disposition because there is no genuine issue of fact that those managers were authorized to remove Mr. Trevor. And again, there's no genuine issue of fact that they were authorized to take that action. It's not necessary to show that the court agrees with that conclusion or that it would have reached the same conclusion. The court should not be replacing or second guessing the board of directors or the managers of the company. That's not really the appropriate role of the court in a case like this. All we need to do is show that the action the co-managers took was not malicious or arbitrary. And there's plenty of evidence that we've presented that the action they took was not only justified, but perfectly reasonable under the circumstances. So on that basis, the willfully unfair and oppressive claim fails because under the plain terms of the statute, if the action taken is authorized by the operating agreement, which it is in this case, then it's not by definition willfully and unfair oppressive conduct. Also, the fiduciary duty claim fails. And the reason for that is because managers in a company do not owe a fiduciary duty to each other, they owe a fiduciary duty to the company. And this is not a derivative claim on behalf of the company. This is a claim on behalf of Mr. Trevor personally. I also want to mention that Mr. Trevor still has remedies under the operating agreement. The operating agreement gives him an entitlement to a buyout of his equity. He's entitled to review an appraisal of that equity and to retain his own appraiser to review what his equity is worth. And my clients are ready and willing to proceed with that according to the operating agreement that they all agreed to. But coming to the court and asking for some other remedy is not appropriate. So we ask that the court dismiss counts 1 and 2. Regarding the fraud claim, which is count 3, we do have limited facts about exactly what this unauthorized credit card use involves. There were no specific transactions set out in the complaint. We believe it has to do with an American Express card that was in the company's name. It was actually a company card that was issued to both Mr. Ansonick as well as Mr. Trevor. It may have been authorized using Mr. Trevor's personal credit. It's not clear at this point what transactions we're talking about. So we filed the motion for more definite statement. I filed the motion to dismiss as well to kind of preserve that argument because it hasn't been brought as a derivative action. So to the extent that Mr. Trevor is not personally damaged by this, then it really is a derivative claim, not an individual claim. And as I set out in the brief, the derivative claim requirements are just not met here. But you may want to hold that portion of this under consideration until we get more details about, consistent with the motion for more definite statement, what transactions are we talking about here? Because again, it's just not clear based on the complaint, if we're even talking about that particular American Express card. I believe that's all I have for now. Do you have any questions? I'd be happy to answer them.
I do, and you're much more familiar, obviously, with the operating agreement than I am, having just read through it as part of my preparation for this motion hearing today. But looking at 6.6, there's not a lot in there about how, the procedure, I guess, that different managers are supposed to follow. So obviously, in this case, it appears that Mr. Ansonick and Mr. Bonnell agreed to use that provision to terminate Mr. Trevor's interest. But what happens if each of them doesn't agree? I mean, what if one person believes that a manager or member has committed an act that would qualify to have that member removed under 6.6 and one or more of the other ones don't? How does that work? I mean, unless there's a different provision that I missed in the operating agreement that spells out how 6.6 is to be carried out.
The operating agreement, go ahead, I'm sorry.
Because, you essentially got two members saying 6.6 applies and one that doesn't. And I get how that might work under this circumstance, but how would it work if the offending party is out of the equation and it's just the two remaining ones and they don't agree on whether what the other person has done qualifies?
Yeah, so there are certain actions that are defined in the operating agreement as requiring a majority or, requiring a unanimous vote of the members or a certain threshold of votes of the members. Typically any action requires only a majority of the managers to implement. And so again, that is the answer to your question, is as long as there's a majority of the managers in agreement, then they can take this action.
All right, so one can't unilaterally undertake under 6.6 to try and remove another one without the approval or consent of the other remaining.
Correct.
Managers.
And likewise, unanimous is not, this is not specified as something that requires a unanimous vote, such as disillusionment of the company.
Okay, thank you. Mr. Blumberg, before you start with your argument, I just have a question because it was raised as part of Mr. Slau's reply. The operating agreement that you submitted with your brief appears to be, do we have an agreement that is or a stipulation that that is a prior operating agreement and that the one that the court should be looking at is the one that Mr. Slough submitted?
I don't think so, Judge. I think in reality, this motion is premature. There's been no discovery done in this file yet. We haven't had a pretrial conference. There have been multiple versions of this operating agreement. The one Mr. Slough has submitted to the court doesn't contain my client's signature. There's some DocuSign version of a signature. And there are at least two other versions of the operating agreement that have different language as it relates to section 6.6. Certainly one of the ones that we attached talks about being convicted of a felony as being a basis for a for-cause termination of a ownership interest in this LLC. I don't know how that was changed, when it was changed, but the version that Mr. Slough has before the court has different language than the operating agreement that I was provided. Again, you know, this is partly a C-10 motion, and there is yet to be any discovery done. I'd like to take the depositions of the other members of this LLC to find out why there are multiple versions of the same document and who ran the DocuSign app that apparently has my client's signature on it. So I don't think there's any question. There's no dispute that my client has never been convicted of a felony. And at least in the version of the operating agreement that we were provided, that requires or at least establishes a basis for a for-cause termination if you're convicted of a felony. He acknowledges that he has been convicted of domestic violence in another county and that had no bearing or any impact on the business whatsoever. So we, again, I would respectfully submit to the court, we should have the opportunity to at least engage in some discovery, and Mr. Slough then could feel free to refile his motion or renotice it up once discovery has been conducted. Because right now, it appears that the two minority interest owners of this business have willfully tried to get rid of the majority shareholder or the majority interest holder in this LLC. Again, I think it's premature at this point for the court to rule on this motion. As to the fiduciary duty, I beg to differ with Mr. Slough. There's a statute, I think, that's pretty much on point. MCL 450-45.15 talks about the duty, the fiduciary duty that one manager owes to the others. There is this fiduciary relationship between managers of a limited liability company. We claim that, again, if the facts are as we believe them to be, that this was a collaborative effort by the two minority interest holders to get rid of Mr. Trevor without really any basis in fact, that's a breach of this fiduciary duty that's owed. So we think, again, with all due respect to Mr. Slough's argument, we just don't think it's correct. And then finally, in terms of the American Express card, I've already been contacted by debt collectors on behalf of Northern Food Group going after Mr. Trevor for charges used by the other interest owners in this business for personal expenses. That is certainly a claim that Mr. Trevor should have against the other members of this LLC as well as the company itself. So the long and short of it, judges, I would ask the court to take this under advisement, allow the parties to engage in some discovery, and then we can come back and the court can decide whether there's some basis to dismiss this case at this point. I think right now it's just premature. C-10 motions require there be no genuine issue of fact. I think there at this point there clearly is.
Okay, so you're saying for purposes of this hearing today, because the agreement that Mr. Slough submitted as the operating agreement that applies is dated December 27th, 2022, and you're indicating that, or you're not stipulating that that's the governing operating agreement.
At this point, I really don't know that to be the case.
Okay, all right. Mr. Slough, any reply?
Yeah, so in deciding a a motion under C10, the court's got to look at admissible evidence. And there hasn't, I've got an affidavit from my client. We've submitted this. It appears to be a fully executed amended operating agreement. It's been appropriately docu-signed. Mr. Blumberg respectfully hasn't submitted an affidavit from his client or anything to rebut that. Even just a basic affidavit saying that's not my signature. I think the court could use to create an issue of fact on that question. It hasn't submitted that. And I think the court would need to see that before denying the motion. With regard to the authority of the managers that we talked about earlier, I did locate that, and it's under section 5.3 of the operating agreement, subsection C, where it indicates that the board of managers shall require the affirmative vote of the majority of then serving managers to take action. That's all I have. Thank you.
Okay. All right. This is the kind of motion I think that lends itself to a written opinion by the court, particularly as it relates to count one being, as Mr. Blumberg argues, premature, and the court ruling on it without having conducted discovery versus some of the other claims, which I think may be more legal claims. So the court is going to address this in a written opinion. I'm going to do that within the next 30 days. So the court is not going to require an answer by the defendants while the court's ruling is pending. Because I believe, Mr. Slough, you filed this motion in lieu of an answer. Is that correct?
We did, yes, as well as the motion for more definite statement.
So the court is going to issue a ruling, like I said, during the pendency of that, the defendants are not going to be required to file an answer. The court's going to suspend until I provide that written opinion, which again, the court's going to do within the next 30 days. The court is going to suspend the time limits under the court rules for responsive pleadings. The court is not going to order a period of discovery at this point. The court will address that as part of its ruling, written ruling, and direct parties how we'll proceed depending on how the court rules as to each count. So in essence, the court is just ordering that the parties hold off on proceeding with the case until the court can rule on this motion in writing. And that ruling will direct the parties as to how to proceed from there. Mr. Slough, any questions about how we're going to go forward?
Just with regard to count 3, Judge, only because even if you do grant our motion, I suppose if you totally grant the motion, that would also dismiss count 3. But, well, even if that happens, we still have to go through this buyout procedure with Mr. Trevor. And I think anything that he is purportedly owed on behalf of this American Express card would still become an issue in that case. So some discovery with regard to either amending the complaint to identify these specific transactions or providing the documentation Mr. Blumberg referenced about collection agencies, just something to give my client a better understanding of what is this claim, what is this card, what are these transactions, so that we can try to resolve that.
Judge, I can do that. I would be happy to file an amended complaint as to count 3 with more specific information about this American Express card and the use by the other members.
Okay, can you do that within the next 30 days then?
Absolutely.
Okay, all right. Do you have any objection to that, Mr. Slough?
I do not. And I mean, my clients want to get that issue resolved if it is in fact an issue.
Okay. Okay, so that's how we'll go forward. And that's all I have for today. All parties are free to disconnect at this time. Thank you.
Thank you.
Thank you.
Okay, Mr. Blumberg, do you have your client there with you? Yes, okay, very good. Thank you. And Mr. Glazer, if you can unmute.
This is the Crowl case I thought we were on. I'm sorry.
I don't have Mr. Dundon signed in yet on Crowl. Were you anticipating Miss Glazer? Do you have her there?
She's in the outside my office in the waiting room. I can bring her in if you want. Or you can just stay.
Okay, that'd be great, please, thank you.
You go out and see.
Okay.
Sorry, we had 2 3 o'clocks there.
Beth needs to come, not you, not you. Okay. You would have thought we were giving something away for free today, Judge. They're breaking the door down.
Got a full house.
Yeah.
Okay, now we have Miss Glazer. Mr. Glazer, are you able to hear me okay?
I am.
Okay, and Mr. Garfield?
Yes.
Okay, we're on the record in Glazer versus Glazer, case number 2319311. We have both counsel present and both parties present, everybody by Zoom. Mr. Garfield, I am in receipt of a motion that you filed today to withdraw from the case, is that correct?
That is correct, Your Honor.
Okay, have you talked with Mr. Glazer about that?
Yes, we have this morning.
Okay, Mr. Glazer, do you have any objection to Mr. Garfield withdrawing as your attorney in this case?
I guess it is what it is. What do I gain from objecting if he's not in it?
I don't know. I can't really give you advice. I
No,
just
I
have to.
hear you. It's if he's not in it, I don't want him representing me.
Okay, so Mr. Blumberg, did you have any input on that issue?
I wasn't even aware that it was up for today, Judge. We weren't provided a copy of the motion.
It just happened this morning.
Yeah, so Mr. Blumberg, Mr. Garfield filed a written motion today. I'm treating this as a verbal motion here on the record.
That'll work.
No, I have no objection. It's just going to slow things down. Right now, they're pretty much at a crawl, so whatever, Judge, whatever you.
You guys aren't doing too hot yourself, Elliot.
Probably not.
All right, I don't want to engage in back and forth here, Mr. Glazer, so Mr. Garfield, I'll sign that order, and you're free to disconnect at this time if you'd like. Mr. Glazer, are you going to hire a new attorney, or do you know how you're going to proceed?
This was just dropped on me this morning. Actually, this afternoon. So.
Okay. Well, it looks like you guys participated in mediation at the end of February. The mediator's report indicates that there was a partial agreement. Mr. Blumberg, from your side, can you tell me what things remain? What are the issues from your standpoint?
Well, Judge, we actually went back. We had a second mediation scheduled, and Mr. Garfield didn't have the opportunity to review the appraisal that was done at that time, so it was rescheduled. We have just retained an expert to value Mr. Glazer's business, and so that needs to be done, and it's going to take probably 45 to 60 days to accomplish that. Once that's done, then we'll be in a position to see where we're at to try to resolve this matter.
Is that the main issue that's remaining from your standpoint?
Yeah, I think it's the only issue. Right now, the house has been appraised, but he has his own business, and there's a real discrepancy as to the values that he believes it's worth and what we believe it to be worth.
All right, Mr. Glazer, do you agree that that's the main issue that remains?
yeah, I guess it's one of them. It's probably their biggest thing. My main issue is to get this thing done and over with. I've submitted a bunch of my things of value to Garfield, and I don't really know exactly what's happened with that stuff. So, I mean, it was a bunch of back and forth. I want every screwdriver. We need to get the cutlery. It's been a tit for tat ordeal. I would almost just subject to putting whatever cards are on the table and letting your honor just dividing it. Just been going on.
You broke up there. Can you repeat just the last couple of things you said?
Yeah, it's just been a tit for tat ordeal all the way from the beginning. She's taking this, I owe that. I just want this thing done and over with.
Okay. All right, Mr. Blumberg, I'm going to give you some time to complete that appraisal. I don't think the court could have a hearing and make any decisions without that. That'll also give you time, Mr. Glazer, if you decide that you do want to hire different counsel, it'll give you time to make a decision about that. So the court will set this for status conference at about 60 days. If there haven't been any agreements, then at that point we'll set it for a final hearing, and the court will we'll set it for a bench trial, and the court will make decisions if there haven't been any agreements on the remaining issues. Mr. Blumberg, any other dates that I can address for your side today?
No, Judge, I guess until Mr. Glazer gets new counsel, I'll be serving requests for documents to him directly.
Correct, yep, okay. Mr. Glazer, any other questions for today from your side?
No, Your Honor.
Okay, thank you. Mr. Glazer, Mr. Garfield, you're free to disconnect, and Mr. Blumberg, I'm going to bring in the other party on our next hearing.
Thank you.
Okay, we'll go on the record in Crowl versus Crowl, case number 2319376. We have both counsel connected by Zoom video along with both parties. This is set for a status conference today on behalf of plaintiffs, or maybe a final hearing. Mr. Blumberg, are we ready to take proofs today from your standpoint?
We are, Your Honor, and we actually have a signed judgment signed by the parties and their counsel. Unfortunately, we don't believe we have it for you to sign it yet. So if we can get that over to you, we can conclude this today. We are prepared to go forward and take the proofs.
Okay, Mr. Dundon?
That's correct, Your Honor.
Okay, Mr. Crowl, can you unmute for me, please?
Okay, unmute.
Thank you. So Mr. and Ms. Crowl, if you both raise your right hands, please. You both solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay. Ms. Crowl, I couldn't hear you there.
Yes.
Okay, great. Thank you. All right, Mr. Blumberg, please proceed when you're ready.
Okay, thank you. So Melanie, you need to speak up so everybody can hear you, okay?
Right.
All right, can you state your full name for the record?
Melanie K. Crowl.
And you are the plaintiff in this action, is that correct?
That is.
On July 18th of 2023, you filed a complaint for divorce in this county. And in it, you allege that on July 11th of 2015, you married Todd Crowl in Berrien County, Michigan. Is that correct?
Yes.
and that ceremony was performed by an individual who was authorized to perform marriages. Is that correct?
Yes.
Your complaint also alleged that you had been a resident of the state of Michigan for at least 180 days immediately preceding the filing of the complaint. Is that correct?
Yes.
And that you'd been a resident of Otsego County for at least 10 days immediately preceding the filing,
Yes.
correct? There were no children born in this marriage. Is that correct?
That's correct.
And you are not currently pregnant. Is that correct?
Correct.
You allege that there had been a breakdown of the marriage relationship to the extent the objects of matrimony had been destroyed, and there remained no reasonable likelihood that the marriage could be preserved. Was that true at the time that you filed?
Yes.
And is that true today?
Yes.
Now, you and Mr. Crowl and your attorneys were involved in a mediation that resolved all of the property issues in this matter. Is that correct?
Correct.
And do you understand that neither you nor Mr. Crowl will be receiving spousal support?
Yes.
And that neither one of you can come back at a later date and ask the court to revisit that issue? Support is forever barred. You understand that? Okay, now each of you are being awarded some real estate in this matter. You're being awarded the real estate at 2507 Fleming Road in Lewiston, correct?
Correct.
And your husband is awarded the real estate at 3518 Goslow Road in Gaylord. Is that correct?
Yes.
Each of you are keeping your own retirements and pensions that you've had both before and during your marriage. Is that correct?
Yes.
The bank accounts that are will be closed, or the joint bank account will be closed, and you are all going to equally divide any remaining funds that are in that account at the time of closure. There's a personal property agreement that is contained within this judgment of divorce that reflects the agreement that you made at mediation. Is that your understanding?
Mm-hmm.
Do you believe that this division of assets of this marriage, along with the division of debts, is both fair and equitable?
Yes.
Are you asking the court to ultimately adopt this as part of the judgment of divorce?
Yes.
Is there any likelihood that this marriage can be preserved?
No.
Thank you. Judge, I don't have any other questions.
Thank you, Mr. Dundon. Did you have any questions for Ms. Crowl?
I don't know if she was asked if she was pregnant. I don't know if I probably didn't hear that.
No.
She is not.
Okay, so that's no questions, Your Honor.
All right, thank you. Mr. Dundon, did you want to take some testimony from your client?
Yes, briefly, Judge, thanks.
Okay, please proceed.
Okay, Mr. Crowl, you heard Mr. Blumberg, correct?
Correct.
And you did read and sign the judgment of divorce that we worked out, correct?
Yes, sir.
And that was done pursuant to the terms of the mediation that we did, correct?
Correct.
Okay, and you also understand you're not getting spousal support in this award, right?
Correct.
And you can never come back and ask for it, correct?
Correct.
That's it, Your Honor. Thank you.
Thank you. Mr. Blumberg, did you have any questions for Mr. Crowl?
No, Judge, but I do have one other question of my client, if I might.
Okay, please.
Melanie, you wanted your, not your maiden name, but your prior married name restored of Owens. Is that correct?
Correct.
Okay, and we're going to be putting that in the judgment. Thank you. I have nothing else, Judge.
Thank you. The court finds that the statutory grounds for divorce have been met by the testimony of both parties. The court will grant the divorce, and once the parties submit that judgment for signing, the court will enter that judgment. Mr. Blumberg, anything further on this file today?
No, Judge. Thank you very much.
Mr. Dundon?
No, thank you, Your Honor.
Okay, thank you. Mr. Blumberg, if you want to remain connected for the next case, Mr. Dundon and you and your client are free to disconnect. Thank you.
Thank you.
All right, Ms. Conklin, are you able to hear me okay?
Yes, I can. Thank you.
Okay, great. And looks like we have both parties connected. And Mr. Blumberg is connected. We're on the record now in Cruz versus Cruz, case number 2319351. All parties in council are connected by Zoom for this hearing today. I have this set as a potential final hearing. Mr. Blumberg, on behalf of your client, can you tell me where things are at?
I would concur, Judge. We have come to an agreement on all of the issues in this case. I have prepared a consent judgment and sent it to council. There are some revisions that need to be made, but I think we can at least take the proofs today until we iron out some of the language in the judgment.
Okay, Ms. Conklin?
Yes, I did receive a proposed judgment from Mr. Bloomberg, and let me take a look here. And yes, there are some items that need to be worked out. However, we have a mediation agreement that has also been provided. I believe the court has that, or at least it's attached. So the judgment of divorce is pretty close to the mediation agreement. There's just a couple of things that need to be discussed. So we could probably take just the statutory proofs today.
Okay, why don't we do that? Mr. and Ms. Cruz, if both of you could unmute, please.
Unmuted, Your Honor.
Thank you. If you could both raise your right hands. Do you both solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
I do.
Thank you. You can both lower your hands. Mr. Blumberg, if you wanted to start with your client, please.
Thank you. Danny, can you state your full name for the record, please?
Yes, sir. Danny Horacio Cruz.
And you are the plaintiff in this action for divorce, is that correct?
That is correct, sir.
On June 26 of 2023, you filed a complaint for divorce in this county, and in your complaint, you allege that on February 24th of 2008, you married Carrie E. Cruz in Fleming County, Kentucky. Is that correct?
That is correct, sir.
And that ceremony was performed by an individual who was authorized to perform marriages. Is that correct?
That is correct. Yes, sir. That is correct.
You alleged in your complaint that you'd been a resident of the state of Michigan for at least 180 days immediately preceding the filing of your complaint. Is that correct?
That is correct, sir.
And you had been a resident of Otsego County for at least 10 days immediately preceding the filing of your complaint.
That is correct, sir. That is correct, sir.
There are at this point no minor children of this marriage. Is that correct?
That is correct, sir.
Okay. You alleged in your complaint that there had been a breakdown of the marriage relationship to the extent that the objects of matrimony had been destroyed, and there remained no reasonable likelihood that the marriage could be preserved. Was that true at the time that you filed?
Yes, sir. Absolutely.
And is that true today?
That is true today.
To the best of your knowledge, is your wife currently pregnant?
No, sir. To the best of my knowledge.
Now, you and I and Ms. Conklin and your wife participated in a very lengthy mediation in this case, correct?
That is correct, sir. Very lengthy.
At that mediation, with the help of Mr. Sheffalo, the parties resolved all of the issues in this divorce, including spousal support, division of assets, division of debts. Do you believe that that agreement and that division was both fair and equitable?
There was one omission, sir.
What was that?
Taxes for 2022 were in and they were filed separately regarding who provided major support, primary support for 2022.
Okay, but that was an issue that was not discussed or resolved. Okay, and I don't think that the court is prepared today to address that issue. So other than that particular issue, do you believe that the agreement reached by the parties was both fair and equitable?
Yes, sir.
And are you asking the court to ultimately adopt that agreement in the form of the judgment of divorce, which incorporates the terms of the mediation agreement?
Yes, sir.
Thank you. Judge, I don't have any other questions.
All right, thank you. Ms. Conklin, did you have any questions for Mr. Cruz?
I don't have any questions for Mr. Cruz.
Okay, then if you'd like to conduct any questioning of your client, then.
Yes, I will. Did you want to swear her in or?
I think I swore them both in at the
Oh,
same
yeah, I'm
time.
sorry. I must have missed that. Sorry
That's
about
okay.
Okay. Ms. Cruz, you are the defendant in this matter, correct?
Yes, ma'am.
And you also filed a counterclaim for as well. So you are both defendant and counter plaintiff.
Yes, ma'am.
And you heard the testimony from your spouse just now.
Yes, ma'am.
And you also recall signing a mediation agreement dated January 26th, 2024.
Yes, ma'am.
Okay, and in that property, debt, and marital property, or excuse me, real property, personal property, military pension, and spousal support were also involved in this mediation agreement, correct?
That is correct, ma'am.
Okay, and do you agree with the terms of the mediation agreement?
Yes, ma'am.
Okay, and then you agree that it will also be reflected in a final judgment of divorce?
Yes, ma'am.
Okay, and you are currently not pregnant, correct?
Yes, ma'am. That is correct. I am not pregnant.
Okay, then I don't have any more questions. Thank you.
Thank you. Mr. Blumberg, did you have any questions for Ms. Cruz?
I do not, Judge.
All right, thank you. The court finds that the statutory grounds for divorce have been met by the testimony of both parties. The court will grant the divorce. Counsel, do you both think that within the next 30 days, you'll be able to have a judgment sent to the court for some? Okay,
Certain
so
of
the
that.
court will just, the court will just direct that counsel submit to the court for signing a judgment within the next 30 days. Other than that, Mr. Blumberg, anything else that we need to address on this case?
No, Judge, thank you.
Ms. Conklin?
No, Your Honor, nothing further. Thank you.
Okay, thank you. That's all for this hearing today, and all parties are free to disconnect at this time.
Thank you very much.
All right, looks like we have both counsel connected. Mr. Tompkins, nice to see you.
Likewise, Your Honor. It's been a long time.
It's been a long time, 22 years, I think.
Just a couple. just a couple.
I hope you've been well. Miss Bailey Quick, Mr. Tompkins and I were classmates in law school, so.
That makes
started
sense. Conversation now.
We started very young.
I was
okay.
gonna say, Judge, it looks like he's aged so much better. No, I'm kidding.
All right, we're on the record now. This is Smith versus Bauer, case number 2319444. If I could just have counsel put your appearances on, please.
Thank you, Miranda Bailey. Quick on behalf of the plaintiff.
Thank you, Your Honor. Matt Tompkins here for the defendants.
Okay, we're on the record today just for a scheduling conference in this case. I'm kind of familiar generally with the underlying facts. I was the judge that presided over Mr. Bauer's criminal case arising out of this incident. So just kind of throwing it out to counsel, starting with you, Miss Bailey Quick. What would you like to see in terms of scheduling going forward? What are your thoughts on how we should proceed?
Judge, I think we can keep it very basic and just defer to the court. We actually have a resolution to my understanding. I'm just in the process of, my client was looking into a couple different alternatives as far as either an annuity or just a straight conservatorship that she has to do an annual accounting for each year for the minor children. I otherwise have all the pleadings ready to prepare the motion for approval and settlement and the conservatorship action. So I just need to follow up with my client as far as whether she's made that decision. And if not, we can just go ahead and file it as a straight conservatorship and she can always convert that to an annuity at a later time.
Okay, thank you. Mr. Tompkins?
That's correct, Your Honor. We did reach settlement in principle. We were waiting on some I's to dot and T's to cross, I suppose, with how best to effectuate that. But I don't know that we're going to need much time at all, other than perhaps 30 or 45 days to get a motion before Your Honor and hopefully get the settlement approved.
Okay. I think what I'd like to do then is just set this as a control date for a status conference in about 90 days. If for some reason it hasn't been resolved and we don't have a motion to approve by that point, then that'll at least have a date out there for us to speak again. But setting that date with the idea that we'll have this resolved prior to that point. Ms. Bailey Quick, do you have any objection to that?
No objection, Your Honor.
Mr. Tompkins?
None, Your Honor.
Okay. All right. That's all I have for today. Ms. Bailey Quick, anything else that we need to address for your side while we're on the record?
None, Your Honor. Thank you. I appreciate it.
Okay. Mr. Tompkins?
Nothing here, Your Honor. Great seeing you.
Thanks. You too. Take care. I hope you're doing well.
Yep. Likewise. Thank you.
Okay. Thanks. Everybody's free to disconnect.
Thank you.
All right. Sir, are you Timothy Patrick?
Yes, Your Honor.
Okay. And it looks like Miss Patrick is signing in. Miss Patrick, I just need you to unmute, please. Thank you. Ma'am, are you Penny Patrick? Ma'am, are you able to hear me? Ms. Patrick, I think you need to connect your microphone or connect your audio somehow because I'm not able to hear you. The other thing you can do if you're having trouble, Miss Patrick, is you can just call in. If you follow the instructions that the court sent out, there's a way for you to just call in on your phone. We can do that as well.
I am sorry I made it.
Okay, that's all right. We can hear you now. Thank you. Are you able to hear
All
me?
right. Yes, sir.
Okay, we're on the record now in Patrick versus Patrick, case number 2319520. And we have both parties connected at this point. The purpose of our hearing today is for the court to determine whether or not you've reached any agreements about how to divide up any marital assets or debts. So Mr. Patrick, as the plaintiff, I'll ask you first. Have you been able to reach any agreements, or are there still issues about how to divide up any assets or debts of your marriage?
There are still issues.
Okay. And Ms. Patrick, do you agree with that?
Yes, sir.
Okay. So what I'm going to do is I'm going to have the two of you participate in a process called mediation. That's where you meet with an independent third party. They try to see if there's any common ground or any resolutions that they can help you guys come to. Neither of you is required to agree to anything in mediation, but that mediator will see if there's any way to find, like I said, some common ground between the two of you. If you're able to agree in mediation, then we'll set this for a final hearing and we can finalize the divorce. If you're not able to agree, then the court will set it for a hearing, and then the court will make determinations on how to divide things up. The mediation will occur by Zoom, just like the hearing we're doing today. Somebody from the mediation service will be in touch with each of you to find a date and time that works for everybody. Mr. Patrick, do you have any questions about that process or how we're going to proceed?
No, Your Honor.
Ms. Patrick, do you have any questions?
No, Your Honor.
Okay, so both of you should be expecting a call. It's from Community Mediation Services. That's who'll be contacting you. So please follow up with that call when you get that. And then I will send out a notice of the date and time for the next court hearing. And again, we can use that time to finalize the divorce if you've been able to agree. And if not, then we can set it for further hearing. That's all I have for today, and both of you are free to disconnect at this time. Thank you.
Thank you.
Thank you.
That also concludes the court's afternoon docket. The